Welcome, legal eagles and armchair lawyers. Buckle up, because today we're diving headfirst into the wild, wacky, and often wonderfully absurd world of evolving employment law. Prepare to be amazed, bewildered, and maybe even a little bit terrified by the sheer unpredictability of it all. We're talking about cases that'll make you question the very fabric of reality, judgments that'll leave you speechless, and legal loopholes that could swallow a small car hole. Get ready, because this is a roller coaster ride, and we're just getting started. The landscape of employment law is in constant flux, a shifting sand dune constantly reshaped by landmark court cases, evolving societal norms, and let's be honest, the occasional truly bizarre lawsuit. We've seen a dramatic shift in recent decades, moving from a more employer-centric approach to a greater emphasis on employee rights and protections. But this shift hasn't been smooth. It's been more like a bumpy off-road adventure, full of unexpected twists and turns. One of the most significant changes has been the rise of gig work and the ensuing debate over employee classification. Are Uber drivers employees or independent contractors? What about freelance writers or social media influencers? The lines are increasingly blurry, leading to a flurry of litigation and legislative efforts to define these ambiguous roles. I mean, seriously, some of these arguments are so convoluted, they'd make a 3-year-old's logic puzzles look like linear algebra. And let's not forget the ever-expanding scope of workplace harassment and discrimination laws. The definition of what constitutes harassment has broadened significantly, encompassing subtle forms of microaggressions and creating a much stricter standard of accountability for employers. This is a vital development, ensuring a safer and more inclusive work environment for everyone. But it also presents significant challenges for businesses, demanding a heightened awareness and proactive measures to prevent and address any potential issues. One can only imagine the creative, and sometimes utterly ridiculous, defenses some employers have attempted to use in these cases. I wonder what planet the judge was on when they delivered that verdict. Then there's the issue of remote work, a phenomenon that has exploded in recent years, upending traditional notions of the workplace. The rise of remote work has brought with it a whole host of new legal challenges, ranging from data privacy and security concerns to questions about worker compensation and benefits. How do you ensure fair wages when employees are scattered across multiple time zones and jurisdictions? How do you maintain a healthy work-life balance when the office is literally in someone's bedroom? These are complex issues that are still being debated and refined, and the legal landscape is still very much in formation. The legal battles over employee privacy are also heating up. Employers are increasingly using technology to monitor employee activity, raising serious concerns about surveillance and the erosion of personal autonomy. From keystroke monitoring to social media surveillance, the potential for abuse is substantial, leading to significant legal challenges and legislative efforts to protect employee privacy rights. Some of these attempts to monitor employees are so over the top, they're almost comical. When you hear this lawyer's defense, you'll spit out your coffee. Another area experiencing rapid evolution is the legal framework surrounding employee compensation and benefits. The fight for fair wages, affordable health care, and adequate paid leave continues to be a central theme in employment law. We're seeing increased pressure on employers to provide competitive compensation packages and benefits, reflecting a growing awareness of the importance of employee well-being and economic security. And the creative ways some companies try to skirt these responsibilities, well, let's just say they're as inventive as they are ethically questionable. The increasing use of artificial intelligence in the workplace is also posing significant legal challenges. From algorithmic bias in hiring processes to concerns about job displacement due to automation, the legal implications of AI are still largely unexplored territory. We're navigating uncharted waters here, folks, and the legal community is scrambling to keep up. The potential for unforeseen problems is vast, and the legal ramifications are likely to be far-reaching and complex. The intersection of employment law and social justice is also a rapidly evolving field. The fight for equal pay, the protection of LGBTQ+ rights in the workplace, and the accommodation of employees with disabilities are all areas where significant progress is being made, but much work remains to be done. It's a constant push and pull, a battle for fairness and equality that's far from over. And some of the arguments raised in these cases are frankly mind-boggling. You'll be shaking your head in disbelief. Furthermore, the global nature of the modern workforce is adding another layer of complexity to employment law. International employment contracts, cross-border data transfers, and the enforcement of labor standards across different jurisdictions present significant challenges. Trying to navigate these complexities is akin to trying to solve a Rubik's Cube blindfolded while riding a unicycle, challenging, to say the least. The changing landscape of employment law is not just a matter of legal technicalities. It's a reflection of broader societal shifts. It's a conversation about power dynamics, worker rights, and the evolving relationship between employers and employees. It's a conversation that's constantly evolving, constantly being redefined, and constantly surprising us with its twists and turns. So what does the future hold for employment law? It's difficult to say with certainty. But one thing is clear: the legal landscape will continue to evolve, shaped by technological advancements, shifting societal norms, and the inevitable wave of innovative and sometimes downright absurd lawsuits. One thing's for sure: it's going to be a wild ride. We'll be here to document it, analyze it, and maybe even laugh at it along the way. So stay tuned, legal enthusiasts, because the show is far from over. The next chapter in the saga of employment law is just beginning, and it promises to be just as unpredictable and just as entertaining as the one we've just explored. Until next time, keep those legal briefs sharp and your sense of humor even sharper. This is where the truly bizarre meets the seriously serious, and it's a spectacle you won't want to miss.